while I hit it. Is that okay?
Yep, thank you.
Okay.
Good afternoon and welcome to this meeting of the Indiana Justice Reinvestment Advisory Council. My name is Chris Goff. I serve as an Associate Justice on the Indiana Supreme Court, and I have been designated by Chief Justice Loretta Rush to serve as JRAC's chair. I want to open our meeting by thanking all of the JRAC members or their designees for giving your important time to service on this important committee. A little bit later in our meeting, I will be calling on each of you to make a report out on behalf of your organization's work and as it relates to JRAC. Before I do that, we are going to conduct several items of business. And the first of those items is approval of the minutes from the last JRAC meeting. And so prior to today's meeting, each of you should have received a copy of the November 16th, 2020 meeting minutes. If you've had an opportunity to review those minutes, I would, at your discretion, entertain a motion to approve them.
Justice Goff, this is Adam. I would make a motion to approve the last month's meeting minutes.
Adam McQueen.
Italian second.
Right. Adam McQueen moved, and then Senator Italian seconded approval of the minutes. Any further discussion? Very well. All those in favor, please indicate by saying aye.
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 Opposed?
Aye.
Right. There are no opposed, then the minutes will stand approved as presented. Thank you. The next item for consideration on our agenda is a report from the JRAC Quick Response Group. First, we're going to hear an update and discussion on case studies on local jail populations. And for that report out, I would call on Mary Kay Hudson.
Thank you, Justice Goff. I would like to present to the council a follow-up from previous meetings surrounding the small quick response groups review of the jail populations during the pandemic. At a prior meeting, we reported out to the council that we had identified 11 counties to take a look at their jail populations between the periods of March and July of 2020, just to get a better understanding of what was happening with the pandemic and practices surrounding the pandemic that may have been impacting their jail populations. We did give an oral report to council at a previous meeting. Since then, we have finalized a report to the council, which was included in your meeting materials. And essentially, the group boiled down the activities within the counties into two categories. Those primarily consisted of actions that were taken in response to uniquely pandemic conditions that either had either been discontinued or have since changed since the start of the pandemic. And so those were practices that possibly were impacting jail populations that were not likely to continue. Examples of that may have been suspended warrant service or reduced law enforcement policing in the community due to curfews and things like that. And then the other category of practices were things that were adopted, either newly adopted or had been in place for a little while within the county, but were expanded during the pandemic, which was things like use of the pretrial risk assessment tool in terms of assessing individuals when they were booked into the jail and who could be safely released to the community. And then ultimately, we identified that there were counties who did not experience significant reductions in their jail population during this period of time, which could in part be attributed to the fact that those counties had already had policies and procedures in place that were designed to prioritize the use of their jail space for those individuals who posed a risk to public safety. So we didn't necessarily want to assume that counties who had not had significant reductions in their jail populations weren't doing things well, or were not concerned about the pandemic conditions, but they were already making good use of their jail resources. So as a result of that study, the small work group really recommends that the council continue to review the recommendations in the Jail Overcrowding Task Force report that was published December 1st of 2019, as well as this council's report on pretrial and bail reform issues that was also published on December 1st of 2019. The small group thinks that those were well vetted issues and recommendations that were published by both of those groups. And they really do serve as a roadmap for this group to continue its discussions surrounding jail overcrowding and implementation of evidence-based practices. So we submit this report for the council's consideration and adoption.
Thank you, Mary Kay, for that report out, and thank you for all members of the small group. Are there any questions from any of the council members or their designees for Mary Kay or members of the small group? Right.
Not a question necessarily, but a comment. I
Yes,
appreciated the fact that the report outlined that some of the statistics that were gathered could be a little bit counterintuitive from the standpoint that significant changes in jail population may not be an indication of perhaps maybe what you might think at first expectation. I guess I would, for counties that experienced a significant change in jail population, that may be an opportunity for them to take a look at pretrial practices and see if there are some things that they learned from that experience may allow them to continue some of those practices for the future. And so I think that particularly that may be, this may be informative from that standpoint. And so I appreciated that point was made in the report. I did want to kind of highlight that issue as well, so that there's not a misimpression that counties that had not seen significant changes in their jail population because they were already doing some things pre-trial that were getting people that we would expect to be released out of the jail. We want to make sure that point is made and understood.
That's an excellent point, Judge Spitzer. So many of the counties that were doing things the right way would not have necessarily shown a dramatic decrease as you indicate. So thank you for bringing that up. Are there any other questions for Mary Kay or members of the small group, or any other observations that members of the council would like to make before we act on Mary Kay's request? All right. So hearing none, Mary Kay, I understand the request of the group is that JRAC adopt the report and continue to work on the recommendations that have been made in not only the report submitted by the small group, but also the two earlier reports that you referenced. Is that correct, or have I missed something?
Yes, Justice Goff, I would make a motion that the council adopt the report as submitted by the small work group on the study of COVID-19 jail populations.
I'd second that motion.
All right. So we have a motion and a second by Mary Kay and the second by Judge Spitzer to adopt the report. Is there any further discussion?
Yes, I just have a question.
Yes,
once we adopt the report, what's the consequence of that? What happens next?
Yeah, excellent question, Mary Kay. Do you? My understanding is that we've got some goals that were set out in the two earlier reports, and what beyond those goals might be illuminated or brought to light in the small group report that we would continue to work towards.
Well, I think one of the primary takeaways from the report was we have a better understanding of the factors that were really influencing the jail population during that period of time. Mid-March is when we started to see the significant decrease as reported by the local jails themselves. And then through the second or third week of July is when we started to see some of those numbers tend to trend back up. And I think that there were some concerns about that. There was questions as to why the numbers were so low. There were some concerns about why they were getting higher. And so I think the biggest takeaway for us as a group is to really understand that these are dynamic conditions. There were multiple factors that were influencing the jail populations. And so that for many jurisdictions, those significant reductions were attributable to very specific conditions that are not likely to be sustainable or not likely to reoccur in those communities. So we wanted to know that and understand what those were. And then from there, really help refocus the work of the council on the review and recommendations that were already published by the task force last year and by JRAC last year as well. Those were really well vetted recommendations. They hold true under pandemic conditions. They're still true today. And so I think our small group thinks it's really important to continuously revisit those recommendations so that we can make sure that we're really focusing on all of the conditions that really need to exist ultimately for us to be able to effectively manage jail populations. So Senator Talion, that's a long way of saying really it helps us better understand what was happening. And I think it reinforces the efforts that the council can make to support those two reports and recommendations from last year.
Thank you.
Thank you, Mary Kay. Senator Talion, does that answer your question, ma'am?
Yes.
Thank you. Thank you for that. Are there any other questions for Mary Kay or other members before I call for the question? Okay. So we have a motion and a second to accept or adopt the report as submitted. I'd ask then all those in favor, please indicate by saying aye.
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 Any opposed? Right, motion carried. The report is adopted. And my thanks and compliments to Mary Kay and members of the small group. Thank you very much for that important and really difficult work. I next ask for a report out from the racial equity small group. And for that purpose, I'd call on Bernice Corley and Steve Luce.
Morning or afternoon, sorry, everybody. Steve, is it okay if I go ahead and give the report, or would you like to? I know it can be a while to find the unmute button, so I'll just go ahead if that's okay.
Sure, please.
So we've added, since our last meeting, more members. I reached out to Justice Goff to get approval to add non-JRAC members to join. He gave approval to do that. And so the committee is now a little bit more representative of the membership of JRAC. And we plan to have a first meeting hopefully in January. My goal for the first meeting is to do a data inventory, make sure that everyone who is looking at equity understands the data that Indiana already collects, reports that are already generated around inequities, to be sure that we're not coming up with suggestions that just recreate the wheel or don't take into consideration what already exists. So that's where we are at this point. I've reached out to state agencies that I believe already collect data that is organized by race. And I've asked those agencies to just give a summary of what they collect that's criminal justice related, organized by race, and any reports, if any, around that data. So I'll be hopefully getting that soon and organizing it for the first meeting.
Are there any questions for Bernice or Steve? Hearing none, Bernice, I really appreciate your leadership in this important work, and thank you. It's an excellent idea to reach out and expand membership on that. So I know we'll look forward to hearing from you then after the first of the year. Well, moving on in our agenda then, the next item for consideration is discussion and voting on legislative proposals. And the first proposal for consideration is the proposal with respect to local JRACs. And for a report out on that subject, I would call on any or all of the following. Representative Fry, who I know has joined us, Christine Blessinger from the Department of Corrections, and or Mary Kay. So take it away, folks. Representative Fry, I think you're muted, sir. There you go.
Okay, thank you. I'm very sorry. Mary Kay, I don't know if you want to take that off or you want me to do that. It's up to you. Got it. I'll do it.
Sir, I'll let you review that. Thank you.
Okay, Justice Goff, is it okay if we just talk about the changes that we've made since the last time we talked about this legislation, or would you like an entire rundown?
You know, from my perspective, Representative Fry, it would be perfectly acceptable to cover the changes. And then certainly, because the members have had the original draft since the last meeting, if there are any questions concerning any of the language, I think that we'd be prepared to field them. But if you want to start with the changes, that would be acceptable, sir. Go ahead.
Thank you very much, Justice Goff. So after our last meeting, we had some discussion, as you may imagine, and we had some assistance from both the Speaker's office and the Department of Corrections. And then there were a couple of changes that were made, and they are in the PD that you have with you. I'm trying to get back here to I think page 2, line 31, review and evaluating state and local criminal justice system sentencing for disproportionality. This is a portion that the Speaker wanted and wanted for us to study that and to see if we could determine I guess whether the scale is balanced and I'm trying to find my notes here real quick, sorry. But whether the sentencing is disproportionately and across the state, I think was his biggest concern there. The second change that we had comes on page 6 and line 2, and it says 2 or more counties may jointly create a regional local advisory council under this section. So what we wanted to do was we wanted to allow a regional local JRAC if that was the decision of the locals. Would not be our decision, would be theirs. In one particular instance, we have Ohio County, which doesn't have a jail, nor do they have a prosecutor they share with Dearborn County. So this would help with that as well. But other counties could do it also, and it's 2 or more. So you could have 2, you could have 3, or whatever works in your area. And then the page 7, lines 1 through looks like 10, the Justice Reinvestment Advisory Council established as amended by this act shall conduct a review of Community Corrections Code provisions in the Indiana Code and make recommendations to improve operations with evidence-based practices. That was requested by the Department of Corrections and was added into the language. Those are the 3 changes that I'm aware of. Mary Kay, do you know of others that we should bring up?
No, sir, those are the changes since the last discussion.
So Justice Goff, I'd be happy to take any questions if people might have.
Thank you, Representative Fry. I see we have at least one question. I'm seeing Senator Talion. Go ahead, ma'am.
Thank you. Just to report to the committee, by the way, I will be the Democrat ranking member on the Corrections Committee again this session. Just a couple of technical questions. Why are we doing an emergency, and why is the section ending in 2022? Very last page.
That's a good question, Senator Talion. I may have to call on Mary Kay or someone else to give you those answers. I can't, I don't know right now. We'll have to find out the answers for you, Senator.
All right, sometimes LSA just puts stuff in there, so I would just say that we look at that. If we do an emergency, it means it's, you know, it doesn't wait for the usual time period of July 1st. And I don't know why we're doing that. But in this case, I get my other question about the expiration date is, are we planning that this local JRACs are only going to have one report ever?
Senator
Because
Talley, and
that's
I'm sorry, I didn't mean to interrupt you, but I can probably address that unless you have other questions.
No, go ahead, please.
I think the intent of section 7 on page 7 was actually the expiration and the emergency declaration was for the purpose of that section. And I think that there had been some discussion about making that a non-code provision so that it wasn't necessarily part of the full statutes under the Justice Reinvestment Advisory Council. So we wanted to declare an emergency because of the fairly short timeline between July 1 and December 1st. And so that in the event that the bill was passed and signed by the governor prior to that, that JRAC could begin that work and have a little bit more time. So the expiration really is only intended to be for the study of the community correction statutes.
Okay. Well, the emergency. Okay. Thank you. That's good enough.
Justice Goff, I have a question.
Please, Judge Spitzer, go ahead.
On page 5, at line 38, it shows that the judge would be appointed by the president of the Board of Commissioners. And I wonder if there's in separation of powers, in deference to separation of powers, if we couldn't come up with a different way to select whoever the judge is, perhaps by the judges in the county voting from one of their constituency to serve on that, or some other way where it wasn't the county executive that was picking the member of the judiciary.
Yeah, Judge, I'm not sure if Mary Kay or Chris, Representative Fry can speak to that particular language as to selection of the judge participating.
I don't know, Judge Spitzer, thank you for pointing that out. I don't know that I noticed that in a prior version, and I would agree that certainly from the Office of Judicial Administration's perspective, our recommendation would be is that that judicial position is selected from among the judges in the counties by the judges in the county.
Justice Goff, if there's a desire to make that change, we can make that change, probably as an amendment now in committee.
Okay. Very well.
Thank you.
Are there any other questions from members of the council? Any other input? And this is an item that's been under consideration and the topic of discussion for, I believe, this is the third meeting.
Justice, I have questions on the new language and the original language.
Sure, please, Chris, go ahead.
Yeah, on the new language, I just wonder if anyone else shares my concern about the disproportionality language and whether that needs further clarification. Generally speaking, disproportionality talks about the offense, and in 1006, every single criminal offense was reviewed and examined for proportionality. And I think under the law, any sentence within the range would be a legal and proper sentence. And so I'm just wondering if that needs further clarification, because along with that, there's also some new language on page 6, lines 36 and 37. I don't think this was in the original language, but this talks about the local council will compile reports regarding local criminal sentencing as directed by the advisory council. And, that I don't know how that's going to work out, whether that's handled 91 different ways. But so I'm just wondering what we're seeking to accomplish and how would we best do that? The state of Florida, in their criminal justice review implemented legislation that requires really good data collection. And if that's the goal, I think that would be a good route. But so I'm just trying to figure out how to make this part work, and wondered if anyone shared those concerns.
Right, very well. Fair point with respect to the revisions and the added language. Does anyone have any thoughts about the questions that Chris raises?
But I guess from a judicial perspective, I think the point that I would make, and I do share some of those concerns with Chris, I think the point that I would make is if the concern is that sentences on individual cases may be excessive, there's a remedy for that. And on appeal, that the Court of Appeals or the Supreme Court has the ability to review sentences on an individual basis and in essence, substitute their judgment. Now, Justice Goff may disagree with how I characterize this, but substitutes their judgment for the judgment of the trial court in entering that sentence. So, 30 may be too many, and so we're going to make it 21. And so sometimes that can be a little bit frustrating for trial court judges. But the fact of the matter is that is available to litigants on an individual basis. So there's a remedy already for what we would consider to be outliers with regards to sentencing. If it's data collection, I'm with Chris. I'm interested in data. But if it's something else that involves sort of invading, the discretion of a judge in an individual case to impose an appropriate sentence. As a sentencing judge, facts matter. And some cases are very different than other cases, even though the charges are the same. And so that's why we have these ranges of punishment for sentencing to allow for that. And then the fail-safe on that is 2 levels of appellate review to determine whether or not there was an error made at the trial court level. So we've built that into the law already. So I'm a little bit with Chris on this issue.
I also have a question.
Yes, Bernice.
Sorry to interrupt, just Senator Italian.
Go ahead.
I guess I see it the opposite of, and I mean, I think the point of these local advisory councils is to ask a community to look at itself and how it's choosing to use its criminal justice resources and how it's applying them for self-help and learning purposes to just stop and examine. And I don't think that there's anything wrong with examining, and I don't even see it as a case-by-case examination of sentences necessarily, but perhaps obviously you have to start with a case, but you collectively look at them and look at how you're sentencing on certain offenses and evaluate, is this how we want to use our our resources, and make a local decision. So I don't know how stopping to examine how sentencing practices are happening and making a determination of whether is this how we want our county to proceed is a bad thing, regardless of whether in individual cases people have a remedy. So I think it makes sense to leave it.
Thank you, Bernice. Senator Italian, you wanted to say something as well, ma'am?
Yes, please. I just have an issue with using the word disproportionality. You have 150 legislators who spent 4 years talking about disproportionality in sentencing. And what we were talking about was, does the range of sentence fit the crime? Now you're looking at a different issue, which is how different counties may use that sentencing range, and whether there's, and I don't want to say disproportionality. think we should choose a different word, just because it's going to, I think, cause confusion. So now we're looking at whether one county is there a vast discrepancy between what different counties do? I just wish that, I think that it threw me that we're using the word disproportionality, because we've already sort of co-opted that word, you know what I'm saying? To talk about the sentence fitting the crime, as opposed to comparison of different counties.
Yeah, good point.
Justice Goff?
Yes, Mary Kay.
Well, I mean, I hear what Senator Talion is saying and what Chris and Judge Spitzer are also saying, but I think I'm hearing also what Bernice is saying. And I think this is, although perhaps it could be worded differently to be more clear about what the objective is, I view this as the criminal justice version of what has happened with the juvenile justice system, and looking at what was previously referred to as disproportionate minority contact. And perhaps the Criminal Justice Institute or Devin would have some suggestions on how we could frame this in a way that really serves its intent, because I think the intent that I suspect Speaker Houston was imagining was similar to the reason that this group has formed a race and equity group. And I think we are seeing on the part of trial courts and local systems a lot of interest in trying to take a look at these issues. We have a couple of courts who have approached us about being able to collect and pull data on some of these issues at the local level, and it's very complicated. But I do think that it's in the spirit of looking at things very broadly as opposed to at a case level. So I would propose that we, before we voted to strike this language, that we might make some attempts to, which I think that's already been filed, so it would have to be an amendment, but that we have some discussion around what alternative language we could propose.
Yeah. And I think that's, Mary Kay as always speaks my mind probably better than I can, but I wanted to say something earlier in the meeting when particularly Senator Talion was asking about the effect of adopting the small group report on response to jail overcrowding during the pandemic. And it's really this, the concept behind this statute is to build an infrastructure whereby the state is able to collect meaningful data, right? And to make informed decisions among a diverse group of stakeholders about systemic concerns. And so the concern, as I understand it from our members, is that we don't want this to be a substitute or a usurpation of local decision-making and discretion in individual cases. And that's true. That's a valid concern. But I think what Mary Kay is indicating, that some of these things must be looked at. I mean, the ability to review and revise sentences according to Appellate Rule 7B is a useful tool in a particular case. But unless there is some means by which you can figure out what an outlier is, you don't really know what the costs of those things are. And so it strikes me, whether it's that or whether it's disproportionate minority contact, that there is some value in our having a mechanism in place that would allow us to collect some reasonably uniform data across counties and then figure out what it means. Otherwise, we may be kind of stuck in the same position we are now at about 10 years out, trying to figure out who might have been on duty at the local jail collecting data one way or another. So I don't mean to be flip when I'm when I'm trying to, summarize those things, but I really do see a value in trying to at least preserve the spirit in which I think many of these revisions came from the Speaker's office. They were trying to capture in revising the language.
Justice Goff, I'd fully support what you're talking about there, and I think I've got, it's maybe if we replace disproportionality with something like demographic equity or something like that. I mean, I think that maybe better sort of identifies what it is we're trying to get to, and I think that's something that I would fully support.
Very well. Chris,
Justice Goff, I'm sorry.
Yes, no, please, Mary Kay, go ahead.
Well, I just have one example of what this looks like in practice. And so, for example, when we look at the National Association of Drug Court Professionals and their best practice standards, and one of their best practice standards is equity and inclusion. And it strongly encourages drug courts and other problem-solving courts to review policies and procedures that may inadvertently be reducing access to those programs for certain groups of individuals, whether it's by race or socioeconomic status. And so it's really just one additional part of a programmatic or system level review to ensure that you are not inadvertently not allowing as many people as access to programming and services that could be of benefit to themselves and the community as possible. So I think if we look at it through that lens, which is how I viewed the speaker's recommendation or suggested language, I think we can definitely work with something to hopefully find some common ground to make sure that it's clear what our objective is here.
Thank you. Anything else?
And Justice, just to be clear, I fully support the data collection, and that's why it's very exciting that we've got this, data system coming with ICGI and our county jails and Department of Correction, because that is essential. It was just some of the terminology that I think if we leave it here, it's going to be very confusing for the, wide variety of folks who are going to be seeing this, reading it, and attempting to implement. So.
Very well. And then in the interest of moving forward then, because we are going to be on a clock with respect to getting this, through the process, do we have some consensus then with this? The language in question is, I believe, intended as a means to reliably collect data. Did I say anything wrong by saying that? I don't, and please, I'm just trying to come to some sort of a common understanding so that we can give some degree of approval, hopefully, to the product that Representative Fry's bringing to us. And if that's the case, and we recognize that there's a need to balance that against a concern over usurping local control, that language that's been the subject of this discussion will need to be reviewed and perhaps wordsmithed. Did I say anything wrong there?
This is Bernice. And maybe I don't mean to prolong the conversation longer than it needs to be. I guess I understood where Senator Tallien thought the word disproportionality might be a bit confusing. I guess I don't understand how the language is written is a threat to individual case sentencing like that. I guess if we're looking for an objective of what needs to be clarified, I understand that disproportionality probably could be misunderstood and better construed. I think Mary Kay expressed that really well. If what we're trying to clarify or prevent is a needless impact on sentencing decisions, I don't see that this language is directed to doing that, I guess. And so I don't know how we would change the language to do that, if that makes sense.
No, I'm not sure that I have an answer to that, but the concern that I understood Chris raised and that Judge Spitzer raised, I hope I'm saying it correctly, because I think maybe Senator Tallien maybe recognize the same concern that within a particular statute, there is a range of penalties that the legislature has deemed are acceptable. And so to the extent that this language might suggest that there's going to be some other range that you'd be constrained to, that could be problematic. And that's something that we want to avoid. Is that fair to say? That's the concern, Chris or Judge Spitzer? I think
Can I
so.
ask a question then, for example, just to be sure I'm clear? So let's say we're talking about a level 6 offense. Just pick any in your brain, I won't even specify. So pick the offense and then imagine that 20 people in a month were sentenced on that offense. And of the 20 people, most people got the, let's say 15 got the presumptive. And then let's say 5 got the max. And all the people who got the max happen to be of a minority population. If this group saw that, what would you call, how would you characterize the 5 that got the maximum being different than the 15 that got the presumptive? Like, I guess disproportionate is disfavored, but that's the kind of thing that I think it would be helpful if a county looked at, like, oh, that's, I wonder why we're doing that.
Here's my fear, Bernice, and to answer your question, I'd say if you have that fact scenario, then we've got a problem, and it's something that requires something to look at. My fear is that, let's say Smith County, I don't know that we've got a Smith County, so let's call it Smith County, decides that we're not going to impose any jail sentences anymore on any level 5 or level 6 offenses. Regardless of prior history, circumstances of the crime, or whatever. We're just not going to do that anymore. And I'm sitting in Grant County, and I feel, after having a sentencing hearing, that jail sentence is appropriate in this case. If the denominator is determined to be what Smith County is doing, and I'm disproportionate with what Smith County is doing, then, all of a sudden I'm the bad guy. And so I'm concerned about that. And, we are having conversations in Indiana with certain people in the criminal justice system that are saying that no matter who commits this offense, they're not going to jail for this offense. We're just using that class of offense, and it tends to be drug offenses at this point, but nobody goes to jail for that, regardless of their history, regardless of the circumstances of the offense. So the conversation has already started, and it might be in somewhere where we're a little bit comfortable with that, but if that bleeds over to some other offenses, well, then, I'm concerned about that. And so that's really kind of, if you understand kind of where I'm coming from there.
I definitely see your point. I mean, I think, like, when I think about my frontline public defense days, I mean, we all know if you got a traffic offense in Marion County and you got that same traffic offense in a donut county, you're going to be in a different position. It's going to be a bit harsher in those donut counties than if you committed the same offense in Marion. I mean, I think so I hear your concern about a county comparison, I do. But I guess what I'm saying is the example I brought up, the county would never know it, but for looking at the offenses and maybe discovering that. And there might be a whole, like you said, cases are dynamic, and it's more than just what a person's name is and their demographic. There are other factors. And maybe digging in, you might learn that those 5 people who happen to be non-majority have certain factors that contributed to them getting the max, right? So I'm just saying, I think however we capture the language, it's a good thing to ask a county to examine how they're using their sentencing scheme. And that might reveal some things that they would examine themselves. I guess I hadn't thought about a county to county comparison. I'm thinking about a county examining itself and how they're using their resources, and et cetera. So I hope we can come to something that would allow that type of examination going forward in counties. Not that they can't do it now, they can certainly do it now, but we are encouraging an infrastructure, and I hope we would encourage the infrastructure to be concerned about the treatment of people of color in their criminal law systems.
Well, the reports are going to be collected county by county, so I don't think we're
That's
going to be able to avoid a county by county comparison.
You're right.
And that's why I'd be more in favor of the language talking about a demographic. I mean, I think that's absolutely warranted and desired, and I'm completely comfortable with that. So, you know, I don't know that we're disagreeing, Bernice, but I think the language that we have now is not language that I'm comfortable with. And so I guess that's where I'm coming from.
Justice Goff?
Yes.
I have one additional thought. You know, sort of related to Judge Spitzer looking at the county by county comparison. You know, I think one of the things that and we talked a little bit about being in favor of data collection, which I'm very much in favor of data collection. But I think there are some limitations to strictly collecting data and reporting out on that data without having some ability to analyze the data. That's where we run into trouble when we risk the county by county comparisons, for example, or court to court comparisons without having additional context. And that's why I think the study piece of it is so important in addition to collecting the data. So I think if we work on some proposed language to refine this and make the language phrased in such a way that everyone is comfortable, that we can really provide some support to the counties who want to look at this, because there are counties who are looking at this and who are wanting to extract some of their data. And it's extremely complicated on how to report this, especially if you're looking at one particular point in the system, when we know that there are, you know, from our sequential intercept model and EVDM, there are many decisions made at many different points in the system that impact outcomes. And so it really does require a comprehensive review. It's not any single thing necessarily that contributes to proportionality or disproportionality in sentencing. And so we really need to take a critical look at that. It's not just a matter of being able to pull the data. That's step one. So I would really support taking a look further at this language and seeing if we could identify something that everyone's comfortable with that would meet that objective, and put some and empower the locals to take a look at that if they want to take a look at it.
Right, thank you for that. In the interests of moving forward with the legislative process, I think Mary Kay's point is well taken. I don't want to be in a situation where we're not able to lend some support to this if there's any way to do so. I know a lot of work has been put into it. What other discussion do we need to have with respect to it? I'm not sure, Representative Fry, what your time frame is now. You've got this initial product that's already been submitted to Legislative Services.
Right.
Are you, sir, open to continued review and refinement through amendments if need be to try and garner support of any perhaps reluctant members?
Well, Justice Goff, we'll be looking at this legislation all the way through the process, and we will certainly be willing to work with Chris or anyone who has a concern, and Mary Kay, and we'll try to get the language that makes the bill better. I think what we have to do is, and I say this a lot with legislation, it's sort of like making vegetable soup. When you first start, it doesn't look like much, doesn't taste very well, but after we run it through the process, when it's finally done, it's pretty good. So I think I'd like to go ahead and get support from JRAC and go ahead and start the process, understanding that I'm more than willing to work with any of the members to get a better bill and get better language. Representative Talley or Senator Talley, I don't see a problem with the emergency. I'm not quite sure why LSA put it there, to be honest with you, but I don't see a problem with it. So. But when it gets over to the Senate, it'll go through your committee, and I'm sure you'll talk about it. We'll talk about it. And if we need to change it, we'll do it.
Well, thank you. Is there any other discussion then for purposes of today? Is there any lingering reluctance then? If I were to ask for a vote indicating support for the proposed legislation, at least in concept and subject to further review?
Justice Goff, would it make sense, because I think Judge Spitzer is correct that there's a lot of agreement. We're just not clear on language. If this group approved it, agreeing that we would work on an amendment to the language that would then be, agreed upon and hopefully agreed upon in time for maybe the first for committee.
Yeah,
Yes, please, Senator.
I would agree with Bernice. I think people seem to be on board that we want to support the concept, even though we may not support every word in this particular PD. So I would move that we support the JRAC, give support to this bill with the understanding that there may need to be some language revisions. So it's kind of it's a conceptual support without supporting every word.
Justice
And I'll
Goff,
move that.
hey, Senator Italian, I would like to get with Chris and Mary Kay and maybe we can get language that does resolve any concerns. We'll propose it as amendment in committee in the House, and as it comes out of committee, then we'll obviously everyone will be able to examine it. And if we need to amend it on the floor, we can, or we can amend it in the Senate committee. So for me, I'd like to move the bill forward with the understanding that we're just beginning to make our vegetable soup. We're nowhere near the finished product.
I'm going to have at least one member having to step off, and this is really a critical piece of work for JRAC. So the proposal, as I understand it from Representative Fry, is he'd like to ask Chris Naylor on behalf of IPAC and Bernice, if you participate as well on behalf of the public defense community, ask Mary Kay on behalf of court services, and perhaps Judge Spitzer on behalf of the Judges Association to work towards amendment of the proposed legislation in order to resolve the questions that were raised in today's discussion over the language that was added by the Speaker's office. Is that acceptable to you, Chris?
Yes, Justice. I appreciate Representative Fry's approach to this. We had a good discussion after our last meeting, and I did just to make 3 points before we close out. Page 6, lines 2 through 5, this regional concept. I don't know if we need additional language or if that's something that the counties will work out. I don't know if we need to say that there's going to be a vote. I just want to avoid the situation where you have members within a county who have differing views and are either forced to go into another county or they don't get to. I raise that as something to work on if necessary. Then also page 6, line 16, the reference to programs providing for pretrial diversion. Prosecutors would like to see that removed as part of the official language for the local advisory councils. Diversion, like charging, is within the sole discretion of prosecutors. Prosecutors are working on felony diversion programs, so we'd like to see that language removed. And then page 6, line 46, I think we discussed this the last time, this requirement that the locals perform duties required by the state advisory council. We think that's covered under subsection 2 on line 6 or page 6, line 32. Promote state and local collaboration between the advisory council and local advisory council. But just that broad kind of authority on line 46 is a little bit concerning. So I appreciate you allowing me to state those for the record.
All of the points that you raised are all points that were included in the additional language since the last meeting. Is that correct, Chris?
The regional idea, that was new language. The other 2 items were in the original language.
Right. That's right.
Yeah.
Right.
Yep.
Bernice, thank you for that. Bernice, you understand what I just proposed, and the support for the concept, and then recognition that there needs to be some additional work done to amend the table.
I do. And I am comfortable supporting it. And just a quick little response. The language that Chris was concerned about, the promoting pretrial, I can't remember how it read, the page 6, line 16 language. I hope that stays, because we're just asking the group to promote those. And the prosecutor is an elected official. So if this group is like, hey, we don't have these, they can, if they support them, reach out to their prosecutor and say, hey, we notice our county doesn't have this, would you consider? So no one's usurping the authority of the prosecutor. These are just hopefully constituents coming together, and if they decide that, speaking that to their elected officials. So to me, it makes sense to stay. And Justice Goff, I've told my other meeting that I'm going to be late, so I'll just stay.
All right, thank you. Thank you for that, Bernice. And then the additional assistance I think we'd need for this to fly was from OCS and IJA. So Mary Kay, I take it that you'd be willing to assist in the process. Thank you. And Judge Spitzer, you as well, sir.
I'd welcome the opportunity to spend time with my friends Bernice and Chris and Mary Kay, and work together with them with Representative Fry. So I think Senator Tallien, the way that she characterized it, that's kind of where I'm coming from too. I really support the concept. I think it's important, the local JRAC, and just if we can get work on the wording a little bit, and I'm happy to do that, I would support it.
Very well. And Senator Tallien, ma'am, and Chris Blessinger, you've been such good partners throughout this process. You're so generous with your time. To the extent that you would be needed, I'd appreciate if you might consider participating in that process too. I'd like to see a product that everybody was comfortable with. And just for the sake of it, one of the additions that's in there that came up after is the concept of the regional JRAC. And Chris had mentioned a specific concern, which I understand, but I will also say that from the standpoint of flexibility and affording equal access to some of these measures that have just kind of universally been pointed to as important in both of the reports for jail overcrowding and others. I hope that some degree of that can be left in because I think that could really be key as we try and look at ways to collaborate and make efficient use of scarce criminal justice resources. Again, nothing mandatory, but to the extent that certainly independent counties can opt into something like that, I hope that some degree of flexibility will at least be considered as we go forward with that, because I know that was important to several of the stakeholders. Anything else then, folks? With that in mind, can I call for the question that whether or not you would support the legislation that's been put forward by Representative Fry to support a local JRAC. Before I call for the question, is there anyone who needs to abstain?
Justice Goff, yeah, I will have to abstain today.
Thank you, Kirsten Haney.
Thanks.
Same.
And Jay Chaudhry?
I'll have to do the same on this bill.
And Devin McDonald?
Mm-hmm.
Very well, then if there's no further discussion, I'd call for a vote. All those in favor of supporting the local JRAC legislation subject to the amendment protocol that we've outlined, please indicate by saying aye.
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 Any
Aye.
opposed? Any opposed? All right. Well, there's your vegetable soup, Representative Fry. So thank you, and we trust you to make it tasty, my friend. Thank you for that.
We'll do the best we can, and we'll get as many cooks in the kitchen as we can to try to get the best bill possible.
All right.
But thank you.
No, thank you, and I so appreciate everyone's input on that. I feel like I'm back in my Wabash County problem-solving court days. It takes input from a lot of different stakeholders for something like this, but I think that this will end up helping a lot of people. For all of those members who may need to get off early, I know Bernice said she took care of her obligation. Jay was going to have to step off. He may have already stepped off, but Jay is. I want to make sure
here, yeah.
you. Great. If you be happy to allow your opportunity to give a report out if you were willing.
Yeah, I have till 3, so.
Oh, okay.
Yeah, I'm good.
Was there anybody that need to get off at 2:30? That may have just been Bernice. Okay. Well, I'm going to go ahead and keep plowing through then. And the next item on our agenda is proposed amendments to the pretrial risk assessment. So for purpose of that report out, I would call on Senator Talion and or Bernice Corley and Chris Naylor. Folks.
Well, if you don't mind if I start, I had a proposal a year ago to basically, and I'm trying to say it in a short fashion, to take trial rule 26 or criminal rule 26 and basically make it mandatory. It's not. So I was not successful in getting it through the first time. So with the language that way it was written. So we wrote some of the language, trying to make it more palatable to a couple of people who had some heartburn. My proposal basically is to make it mandatory or, well, not mandatory. That was the problem the first time. So then I tried trying to not make it presumptive, but the idea is that the courts should be letting out nonviolent misdemeanors OR. And that's where we're trying to get to. There are a lot of courts who are risk assessment, we believe, but there are also courts that don't seem to be doing it. Bail is supposed to be for the purpose of ensuring that somebody shows up in court. It's not supposed to be for the purpose of making money for the system. It's not supposed to be for the purpose of ensuring that a defendant will pay fees. That's where I'm trying to get to. I have proposed language. I have had discussions with Bernice and with Chris Naylor. We weren't able, I keep getting, and I've also had discussions with Judge Spitzer. I keep getting a response that people have heartburn with this. On the other hand, no one yet has given me alternative language that would make them happy. So I plan to submit my bill this year again, and I would like JRAC to either support my bill or to support the concept of what I'm trying to do. So I will leave this up to discussion. I understand that, I'm a legislator on here. I'm asking for your support. But, I really, I'm a little disappointed that I have not gotten any response that is actual language, if you know what I mean.
All right. Well, thank you, Senator Talion. So my understanding, the process has been 2-3 months of discussion on the subject, that was the hope that we would have some discussion to at least hopefully move towards language that might make different stakeholders more comfortable, and it appears as though we're not there. Senator Talion has asked the group for discussion and either support or some indication of, I suppose, concern. Can we open this up for discussion then?
I can, I feel like I'm talking a lot today, Justice Goff, and I apologize for that, but I can start. I had a good conversation with Senator Talion. I understand where she's coming from. I think she has valid concerns, and I think it's an issue that we can't ignore. I shared with her some of my reservations with regards to the specific language of the bill and sort of the practicalities of implementation. I told her I don't feel that it necessarily, the bill as the language is indicated, gets to where we need to go. I think Senator Talion made the very good point, is that she'd like to find a way to get to yes. And so the one thing that I have done, I also chair the pretrial committee. And so I told her that I would put it on the agenda for the upcoming pretrial committee. I know several of us on this meeting might also be in that pretrial committee meeting as well, which meets Monday. Those would be really sort of the subject matter experts with regards to pretrial. And if anybody's going to have, creative ideas in terms of addressing the concerns, that might be the best forum to do that. I can't promise to Senator Talion that we're going to kick out a bill language from that, but at least we can have the conversation and see if any ideas will bubble up to the top. And Chris and I have also had some conversations about the proposed bill as well. And I think we have some similar shared concerns with specific language. So that's following my conversation with Senator Talion. Those are the things, Senator, that I have done. And so it is actually on our agenda for Monday to discuss. And then my intention would be to report back to you after we have that discussion in terms of what comes up from the pretrial committee. So that's what I can add to the conversation, Justice Goff.
Thank you, Judge Spitzer. There anything else for purpose of this discussion?
Justice, I would add, we're supportive of the review with the pretrial committee. I think that's a really good idea. They are the experts on CR 26 implementation, and we would support legislation that can thread that needle, that helps with the senator's goal, but doesn't go beyond the current scope of Criminal Rule 26. The state has all been working diligently on CR 26 implementation, community by community, and so we're supportive of the continued review by the pretrial committee.
Thank you, Chris. Anything else? Well, Senator Talion, I want to just, for purposes of the discussion, I think it's important in a venue like this to at least explain a little bit about the process that I think Judge Spitzer just outlined. The Judicial Conference of Indiana is composed of all of the trial bench of the entire state, and the conference's purpose statutorily is to really collaborate and develop best practices for the operation of the trial bench statewide. And it's divided into conference committees. One of the newest, if not the newest, conference committee is really a creature designed to meet this this challenge of implementation of CR 26 statewide. Indiana was the first state to certify problem-solving courts in Indiana. Through the process of developing and planning to implement CR 26, a plan was made to have a certification process for county CR 26 pretrial release and reform initiatives. And what's really unique about this committee, and it took some doing, is that it's a multidisciplinary committee. Most of the conference committees are composed just exclusively of trial judges. But the thought with respect to this committee was that when a community implements Criminal Rule 26 and pretrial reform, it's going to depend on collaboration through by all the criminal justice stakeholders. So all of those folks are represented on that committee. And I know it can be frustrating when you're wanting to get something done, but from my work in trying to develop that committee, working with my colleagues and Judge Spitzer, I do agree, ma'am, that might be a very good way for you to get a product that you can be assured will have the most benefit and be of the most practical use as we implement these reform initiatives in all our 92 counties. So If you're willing, would you be willing then to perhaps table this until the January meeting? Or does that
Yeah,
do you
I
any?
was going to say, I was off by a week of when this meeting was. I thought it had already happened.
Oh.
So it's not happening till Monday. Yeah, the next meeting is January 20, is it 21? I don't have it in front of me.
Getting on my agenda. Yeah, we are scheduled for the 29th of January, Senator.
Well, let me say this. I will file the bill because I obviously have to get it filed before then. So it's going to have to be filed. And I can ask the chairman of my committee to give me a hearing in February. But that's my time schedule. You know, I have to have a bill filed by a certain date, first week of January or whatever it is. And I would like to continue to work with all of you on this and get something that will be helpful to the entire state. But January 29th starts to get halfway through the first part of session. So I have to get a hearing before mid-February or the bill dies. So, yeah, I mean, I would be happy to have any input that I could from the pretrial committee with the idea that I have to file this in some form before the 1st of January or before the first week. So, yes.
Understood. Is there anything else for discussion with respect to the pretrial bill then for purpose of today? All right. Well, thank you, Senator Talion, for your dedication to this. I know how important it is to you, and I understand the reservations of different constituent members. There are a lot of people that these folks speak for, and it's important that some comfort level can be reached as we endeavor to go forward with something that we have consensus about. So we'll keep working towards it, and we'll readdress this then at the next meeting.
Thank you.
Thank you. And folks, then with respect to legislative items, I believe we've gotten through the list. And so the next item on the agenda is Indiana mental health system mapping. You'll recall the last meeting we'd heard from Mary Kay Hudson about some work that was being done in collaboration with the National Center for State Courts. She has an important update for us, and I'd call on Mary Kay once again.
Thank you, Justice Goff. At our last meeting, we talked about the process by which we were conducting interviews with justice stakeholders surrounding competency evaluations, competency restoration services, and the overall accessibility and provision of behavioral health services, particularly for those individuals suffering from serious mental illness. So we've continued those interviews. We've wrapped up almost all of our interviews with stakeholder groups, including sheriffs, prosecutors, defenders, community supervision agencies, behavioral health professionals. And so we're going to be having a report published that with the assistance from the National Center for State Courts, probably sometime coming in January, with some findings and recommendations. But at our last JRAC meeting, we did provide this group with some recommended statutory revisions to the competency restoration process statutes, specifically surrounding the assessment process. And so what we wanted to do was the entire package of recommendations that we presented to the group were pretty comprehensive and will likely require some study through this coming session. But there are a couple of points that the Deadwood group, so to speak, identified through this interview process that are very concrete, very specific, and have a pretty significant impact in individuals' ability to move through the system when it comes to the evaluation process. So attached to your materials today, there was the language that was presented to the last meeting, specifically surrounding the competency evaluation process, which currently requires individuals to be subjected to 2 evaluations by 2 independent providers. And then those providers provide the recommendations to the court. What we found through the interview process with our stakeholders is that is a significant area of time delay because individuals who provide those assessments, frankly, the workforce is not sufficient to meet the demand and frequently results in long delays, as many as 4 to 6 months for individuals to receive those 2 required assessments based upon the availability of qualified individuals. So in talking to the stakeholders, certainly there is variation from case to case in terms of whether or not those evaluations are consistent with one another. But by and large, our interviews revealed that for the most part, while maybe the individual reports vary a little bit in terms of scope of review and detail, perhaps based upon the professional qualifications of the individuals conducting those, whether it be a psychiatrist or a psychologist. But generally speaking, there does not tend to be a lot of disagreement in the final recommendation to the court in terms of competency to stand trial. And so for those reasons, and the amount of time that it takes to get those, the expense associated with getting those, and the fact that individuals are typically held in our county jails while they're waiting to receive those evaluations, the Deadwood Group is recommending that there be a statutory revision that reduces the requirement from 2 evaluations to 1. And under the conditions of, after the first evaluation, if one of the parties disagrees with the evaluation, they can petition to the court for a second evaluation. We believe that this would significantly reduce the time and expense associated with completing those evaluations, and ultimately would allow either the case to proceed or would allow an individual easier or more timely access to restoration services. One of the things we also uncovered during our conversations with stakeholders is that sometimes the quality of those evaluations is superior depending on who is completing the evaluation. And so there was a recommendation to incorporate a template that DMHA would provide to those individuals completing those recommendations for the purpose of promoting quality and consistency among those evaluations. So those are currently the statutory recommendations from the Deadwood Group in terms of looking specifically again at the competency evaluation process. The other areas that we reviewed last time, as I mentioned, are very complicated, and our group is working with Senator Sandlin to see if we can have the legislature identify or direct a study committee to take a look at some of these issues over the course of the next year for further evaluation. But Justice Goff, what I'm presenting to you has been discussed and vetted by the Deadwood Group, who's looking at these issues, and Senator Sandlin has submitted this legislation to Legislative Services and asking for a preliminary draft, again, specifically around the highlighted language that you see before you around the competency evaluation process.
Mary Kay, thank you for that. I know Jay's short on time, but I want to offer him the opportunity to chime in on anything about this ask.
Yeah, absolutely. Thanks, Justice Goff. I would say a few things. First, I understand that there is possibly some trepidation around reducing from 2 mandatory to 1 mandatory evaluation. And I do understand why. I think this provides an outlet with the request for a second evaluation while sort of maintaining that frankly is just one of our biggest bottlenecks and biggest sticking points. And it's not going to get any better. I mean, Indiana isn't being flooded with qualified psychologists and psychiatrists. We've got to help overall behavioral health workforce issue, period. And that's not really going to change anytime soon. And so, I think this sort of, in my opinion, this kind of toes the line between respecting the right of somebody to get a second opinion while allowing for a seamless process in the 80 to 90% of cases where that happens to be the case. And the other piece of it, I would say, some of the stuff that was taken out is stuff that if I had my way, which I understand I don't, we live in we have a much more complicated system than that. I would certainly be fully supportive of. And so I think let's not lose sight of the bigger ball here with the stuff we're sending to study committee, and sort of see this as just the opening salvo and not a be all end all approach. And then finally, there's a little piece which I don't think Mary Kay highlighted, but it's in the overall submission. It's highlighted and it really just all that does is it allows DMAJ to contract for pieces of the restoration process, which right now, if you read the statute, it suggests that we can only contract for all of it or none of it. So I would just that would really help us out when it comes to some of these other initiatives that we're trying to pull off, which I talked about last meeting. So that's my 2 cents. And then if I'm not around when we vote, you can record me as voting yes for this particular.
Thank you, Jay. Steve, on behalf of the sheriffs, I wonder if there's anything that you'd like to add to this discussion before I open it up to the floor. I know this is a topic that's been of significant importance to sheriffs.
Yeah, I think the biggest piece is, expediting the process, and, what Jay's been already doing in our communication with the sheriffs and having Sheriff Reynolds involved too. We've already seen some really good results already. And I think we had a call this morning with probably 55 sheriffs this morning, a virtual update, and we keep hearing good things. So I want to tell Jay, I appreciate everything you're doing up there. And I think like Jay was saying, what we have to really look at is a long-term vision here. And the goal is to really have a complete seamless system. And it starts off small and a lot of heavy lifting, but we appreciate the work he's doing.
Thank you, Steve. Doug, is there anything that you'd like to add to this? You've been a member of the Deadwood Group since its inception. And I want to give you the opportunity to add anything if you'd like to before I open it up to the floor.
No, I think, as we've discussed, this really goes a long way to deal with that backlog in our jails. And I really want to thank the Sheriff's Association and Jay and his team. I know COVID put a little bit of a damper on the timeline, but I think the sheriffs understand that we are committed to solving this problem, and whether that be through the work that Jay's already accomplished or through this legislative proposal, it's really going to be, I think, a giant leap forward in clearing this backlog and then ensuring that we're not creating problems downstream as well. So thank you.
Thank you. And Bernice and Chris, I know that you were consulted. I know that you may want to be heard on this too, representing two of the most important constituent groups that would be affected by this. Is there anything that you'd like to add or ask Mary Kay or the other members?
Go ahead, Bernice.
I feel like I've been doing a lot of talking, but since you want me to go first, that's great. Mary Kay, thank you for the summary. I do have some questions. The first draft that we looked at in November had a provision about dismissals if a person wasn't competent, but it's been removed. Can you tell us more about that?
Yes, that was an area, Bernice, that we really felt like needed more study and input from the stakeholders, knowing that it's complicated. There's a lot of things at play. We wanted to make sure that everyone had an opportunity to weigh in on that.
So I just looked at it. So here's my summary of what the bill does, and I just want to make sure I don't miss anything. So, and when I say the bill, I mean the preliminary draft that Senator Sandlin submitted. It would take things down to one evaluator. It would strike physician as a possible person to give a review. There would be a template that would be followed. A second evaluator would be available upon showing of good cause, and then the contract component that Jay referred to. I think that's it. So from my perspective, I was very hopeful about the draft because I thought it would give some relief to accused who have mental health illness, who are caught into the criminal justice system. But by removing the dismissal language, I don't see any benefit for the actual accused. I took some time and I put the question out after our November meeting to defenders, just to get their reactions about the draft. And Marion County public defenders overwhelmingly sort of disagree with the idea that there's rarely any disagreement between the two evaluators. I consulted with several of the PDs who do this work in Marion County, and many stated that they often have situations where there's differing opinion, and they were greatly concerned about going down to one evaluator. Separately, I mean, I've not personally done this work, but my concern is, and I know there's a lot of national support around going to one evaluator, it does save money, it does make things quicker, no question on those points. But I think it does it may in the long haul or in individual cases compromise the rights of an individual. The good cause language, which let me back up. From my perspective, I can see a compromise where having one evaluator is fine, and then having the ability to have a second if requested. The good cause language really is a difficult trigger. It's so vague. And I think it would be easy to not be able to get a second evaluation at all. So I don't find that language as consoling as perhaps it could be if it were easier to get a second evaluation. I think from the draft, it's very good that that physician has been struck. I think that's a positive for sure. I think the contract component that Jay pointed out is a positive. But apart from that, I'm just can't really be supportive of this draft because there's no, in my mind, no relief for the accused, and actually could serve more to harm the person than to help them. If we're going to study things, I think it might be worthwhile to study the one evaluator. I mean, if we're going to study dismissal and whether that's valuable, then I think we should study one evaluator and then have an opportunity for people who do this work to come and say, yeah, one evaluator is fine, or this is the problems we see with one evaluator. So for me, that's just where I stand. I just feel like this was an opportunity to bring some relief, much needed. It just feels like once our criminal justice system gets its teeth in someone, it's like a fighting dog. It won't let go. So even people who have mental health illness, who are in the criminal justice system, who aren't competent, will continue to linger and not have their cases potentially dismissed, when perhaps that decision to continue holding the case and potentially holding them is going to cause them perhaps to lose benefits that they might have, maybe placements that they have because of their mental illness or services that they have, and ultimately put them in a worse position, which wouldn't serve us collectively as a state or that individual. So thank you for letting me talk a lot about this. And Mary Kay, thank you for the summary on all of this.
One quick, real quick, because I gotta leave at 3 to go to a vaccine meeting. So, so I agree with a lot of what you said there, Bernice. What I would sort of suggest a little bit is that making it quicker, which I think fundamentally is what we're trying to do here, would address a few of those things, right? Like the issue of benefits or getting people out, because a lot of times right now we have folks that are just lingering. And they're lingering, waiting for an evaluation. And that time period that we, our data that we collect about how long it's taking to get people in, that doesn't even count time they're waiting to get an evaluation. So when we say we have people 90 days, which we have people under 90 days now, which is a record for the last 5 years. But that doesn't count the month or even month and a half on top of that 90 days. And so, and a lot of times they're sitting in jail. And so that would be my only response, although I agree with a lot of what you said. And then at this point I got to run, but thanks for the opportunity to share.
Thank you, Jay.
Thank you.
All right. Go ahead, Chris.
Thank you, Justice. Prosecutors welcome this conversation. It is so needed. And so we've covered a lot of ground here in just this last 30 days or so when we've started this conversation. And we fully support a study committee and don't think that we need to wait till next summer to do some of that work through study committee. And because there's some major improvements that need to be made both in the adult competency system and the juvenile competency system. So we are very glad that this conversation is being held. In initial conversations with prosecutors, it's very clear that two things that stand out. There is a strong preference for psychiatrists, and Mary Kay hit on that in terms of the adequacy of some of the evaluations. That's a strong preference, and a second strong preference is for at least 2 evaluations. The prosecutors share some of the same concerns that Bernice stated. But in order to try to be helpful, I think in the short term, I think prosecutors would be okay if the language remained the same and it said the court, shall appoint 2 or 3 competent psychologists or psychiatrists unless the parties agree to one evaluation. I think there may be some cases where the parties, could agree to that. And so that's one component where we think that we could help here, and that might provide some relief. Another area could be if the evaluations are ordered at the same time. I don't know if that's being done currently, if that's consistent practice or not, but if those are ordered, 2 are ordered right up front, that may reduce some of the time delay. But there's so many factors here, right? Including the location and the manner in which evaluations are done and restorations are done. Those are all time-saving manners. And I just think that we have a lot of work to do to see what are our funding sources, what's our current spend, what's our current timeline. Is there consideration of a mechanism to screen these requests before you order an evaluation? I mean, should there be some process where judges can screen these evaluations? So that's kind of the feedback from prosecutors. But again, we're very thankful that we are collectively working to improve this.
Justice Goff, could I say a couple of things? Is that okay?
Yeah, please do, Mary Kay.
So I think the feedback from Chris and Bernice is really good, and I think I agree with Jay. The purpose of this, it really is in service to the individuals in the system as well as the community and the public, and trying to strike that balance. I think the intent with reducing it from 2 required to at least to a minimum of 1, or unless the court orders a second one at request, is because we do want these cases to move through more quickly. Again, either for the sake of proceeding to trial, or for the sake of that individual being eligible for restoration services. So, if there's a different way to get there, whether that's lowering the standard for requesting the second, or at the, amending the statute so that the parties can agree up front to 1, I don't have any, I don't have any preference on that. I just, think that in the interest of getting these cases through more quickly, because Chris, to your point about can the court request these at the same time? We talked to one judge who in that community happened to be Monroe County, which I consider to be pretty well serviced by Centerstone. They're only permitted 1 competency evaluation a month. So at a minimum, it's, assuming there's no other defendants in line waiting for a competency evaluation, it will be at least 2 months for those to occur, plus whatever time it takes for the second evaluation report to be developed. So, I think that there is just some structural issues, some system issues that are impacting the ability to get these completed in a timely manner. Marion County doesn't have a shortage of individuals who can complete these evaluations, so time is not an issue for them. Expense is an issue because they're so high volume that they have so many cases that these evaluations tend, what we were told, run around $2,000 or more, depending on the qualifications of the individual administering them, and those come out of the court's budget. Not that we want this driven by money, But again, it's all striking a balance between what is most efficient, what is the best quality evaluation that we can get, what's protecting the rights of the individual, what's in the interest of public safety. It is very complicated. So I think the Deadwood group, subject to Justice Goff and others' agreement, would be willing to work with you all to see if there is ways to improve this language. Because while the numbers are not huge, I think, any individual who's staying in jail and the sheriffs are bearing the expense and the challenges associated with housing these individuals for months on end, if any way that we can reduce that time frame, I think would be of a benefit.
Mary Kay, if I can, I think what Chris suggested of 2 unless the parties agree to 1 is definitely better than what we have here, and would be a movement in the right direction.
I'm just going to go ahead and, in the interest of moving, the Deadwood group had met several times, obviously since first formed a little over a year ago, and in anticipation of the legislative deadline, Senator Sandlin put a bill forward. The consensus of the group was that the other items that were included in the last draft would be tabled with an eye toward assigning a summer study committee to look at these, recognizing that they're credible scope. And I would say, though, with full commitment to seeing that some form of the reforms that were encapsulated in there would be, an end goal for any legislation, because you get people that shouldn't be in jail out of jail, and you realize the cost savings associated with that as well. So that's just something that could not be accomplished on the clock that we had available to us. And so I think the thought was with Senator Sandlin to get something in the pipe. My hope, frankly, is that we would have some consensus that it would be good to get this group of folks that shouldn't be out in the jail move through and not stuck in this terrible bottleneck that's causing congestion, and during the pandemic, perhaps safety concerns, health concerns in the jail. But for the reasons that our colleagues in public defense and the prosecutors bring up, it's complicated and it's hard to reach consensus on that quickly. So I'm committed to continuing the conversation and to getting something that hopefully everybody can be comfortable with. But is there any problem then? The bill has been introduced to doing something akin to what we agreed to do with respect to the local JRAC bill, and looking at this and seeing whether or not some work can be accomplished on an amendment. And then that way, if there's not support, at least among all members, at least Senator Sandlin would know what he was looking at and what he might have to address and putting the bill forward. Does that sound reasonable?
Justice, just to be clear, this is so problematic that I would vote no since this is the only language that's before us. So I just want to make that clear. And
that's what I said. That's what I expected.
Yeah.
And I expected Bernice would as well. So I don't want to put any of the commissioners in a position where they would be advocating something that somebody else might oppose. And frankly, I think if we had the time to sit down and talk through some of these issues, that we would not necessarily be opposed. But these things happen. This is very important, and I think it deserves the time, commensurate with that. So, perhaps that's the way to approach it. Then, if Mary Kay suggested that if we, we convened between now and January with an end goal of coming up with some language that might be able to amend the legislation, is that acceptable to the group? I take it that's
Yes.
acceptable to Chris and Bernice.
Yep.
And then
Yes, sir.
I'd ask then Doug and Mary Kay as members of the Deadwood group. Would that be acceptable to you all as well?
Yeah, that would be fine.
Justice Goff, would there be any value in, I feel like I'm hearing support for study, an explicit study of the problem, and would there be any value to go ahead and voting on that? And then with regards to the language of the specific bill, maybe there's not as much agreement on that, but I don't know if there's any value to us as a body saying we would support study of the problem to the extent it's unresolved through current legislation.
Yeah, you know, I don't want to get ahead of myself, but my first reaction is yes. At least the consensus among the members of the Deadwood group is that this was one reform that was so time sensitive and was exacerbated so much by COVID-19 that there was a desire to get something done this session. And with respect to the larger reforms and improving court and community response to serious mental illness, the consensus of the group was that that was complicated enough that it needed to be the subject of a summer study committee. And if I hear consensus among the commissioners that that's true, that second part is true, that it's important, it should be the subject of a summer study committee, then yes, if there's no objection, I think that might be something that we could vote approval for now. And that might be at least helpful going forward in showing that there is widespread support for that general topic.
If that helps, I would make that motion, Justice Goff.
So any further discussion then? So there is a motion to at least pursue then with JRAC support the idea of a summer study committee to improve court and community response to serious mental illness. Is there a second?
Second.
Anyone need to abstain from that? Hearing no one, all those in favor then please indicate by saying aye.
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 Any opposed? All right, well, thank you for that, Judge Spitzer. Well, then, Mary Kay, perhaps you and I can circle back then. And you know, Doug, if you want to be a part of that discussion as well, I think we're going to need to meet between now and January 29th anyway, but maybe we can just go ahead and endeavor to get a few more people involved in that group so that we can hopefully move this forward in a way that everyone is comfortable with. All right, very good. Anything else then with respect to the report out from Mary Kay on the mapping? No? Okay. The next item then on the agenda is a report out on budget forecast and local impact. If we still have Senator Talion or Kirsten.
Yep, I'm on. I'm happy to just give a brief update. So I feel like I've been saying it for a while now, but the revenue forecast is next week. It's on December 16th at 9 a.m. So that gives us our estimated revenue projection into the next biennium, and also helps us in finalizing what that budget is going to look like in the upcoming legislative session. Along with that, we also have budget hearings on Monday and Tuesday for larger cabinet level agencies. So something just to keep in mind too with budgetary items.
Thank you, Kirsten. Any questions from commissioners? No, okay. Then I'd go ahead and move into our individual report outs. And first I'd ask for a report out from Bernice Corley on behalf of the Public Defender Council.
Thank you, Justice. I actually don't have anything to share this meeting or update about, but thank you so much. And if I don't get to say it, I hope everyone has a really happy holiday. And thank you to everyone who agreed to serve on the Equity Commit work group. So, thank you, Justice.
Thank you. Next call on Chris Naylor on behalf of the Prosecuting Attorneys Council.
Thank you, Justice. not much new to report. And likewise, as Bernice said, I hope everyone enjoys holidays and hopefully everyone can unplug for just a little bit. So thank you, Justice.
Thank you. Steve, anything to report on behalf of the sheriffs?
Just other than we're really trying to work hard with DOC and health department on this vaccine distribution, and can't thank Jay enough for what he's done. And I do know maybe later on Mary Kay and I could, or she could give an update on a grant they received for jail management systems that could be offered to some of the sheriffs that might be helpful with this jail data project, which is also, again, continuing to move forward. But thanks everybody for your time and have a happy holidays.
Thank you, Steve. Next is Christine Blessinger on behalf of the Indiana Department of Corrections.
I'll be brief also, just to let everybody know that our community corrections contracts are starting to be returned to the counties executed. We pretty much have about approximately maybe 75% of them done. And so we're moving forward on all of that. Also still working collaboratively with the jails and as Steve said, with the Sheriff's Association, appreciate all the collaboration there. And we're just continue to move forward with that. So thank you.
Thank you, Christine. Mary Kay, can you give a report out on behalf of the Office of Judicial Administration?
Yes, sir. Just two major highlights from a data perspective. First, Steve mentioned that our Office of Court Technology received a grant through the Criminal Justice Institute and federal funding for the purpose of improving criminal history information, which will include a component to build a jail management system. So Office of Court Technology and our Office of Court Services are partnering with the Sheriff's Association to look at building some requirements for developing a custom-made system, which would be available to sheriff's offices who wanted to implement it. The benefit of the system is it would be custom-made, it would be built to the specifications and requirements of the sheriffs and other stakeholders, and ultimately that system will be connected to Odyssey. So we can all see the benefit of having court information linked to jail information. It would not in any way be required for the sheriffs to use this system, but it would be similar to Odyssey in the sense that we would make it available to anyone upon request, and there would not, cross our fingers, ultimately be any cost to the community for this system. We would intend to support it through our sources, similar to the way we support Odyssey. So we're going to start meeting on that in January, and we'll have hopefully continued updates for the council on the status of that project. The goal is to pilot it in 3 counties or in 3 jails, a small county, a medium county, and a larger county. Hopefully by the end of next year, we'll get started on that. And then on the data side, the supervised release system, which is the community supervision case management system that's also tied to Odyssey, which was developed originally in Marion County, and our Office of Court Technology contracted with the Department of Correction to deploy that system into all community corrections agencies. And we have completed that deployment with our partnership with DOC. It's in all community corrections agencies, which is a huge win from a data perspective on the community supervision side. So now our Office of Court Technology will continue to support community corrections in that system. And then we're also continuing to deploy SRS into the court side community supervision agencies such as probation and problem solving courts. That's my update.
Thank you, Mary Kay. I'd next ask for a report out from Devin McDonald on behalf of the Indiana Criminal Justice Institute.
Thank you, Justice Goff. Like everybody else, I really don't have much to report. I will say that on the first, we were able to get the criminal code reform study in combination with the JRAC report submitted as required. So that's up and available. Copies on our website as well as on the General Assembly's website. So, thank you to my staff as well as everybody else, all the other folks, IPAC and Public Defender and DOC and everybody for the courts for providing all the data that's necessary to write that report. Thank you to Mary Kay and your folks. They were a big help with that part as well and review and everything. So again, that report's available. I can send a link out to the group if anybody would like it from our website. It's easier. It's a much smaller report than what it has been in the past. So it's a little easier to read. It's about 31 pages versus 200 pages. Good for that. But other than that, I really don't have much else to report. As Steve mentioned, the data transformation, the victim notification projects are moving along. So hopefully we'll have more to report on that in the next meeting as well. So, but that's it for now. Thank you.
Thank you, Devin. I next called in for a report out. Is there anyone on the line from the Association of Indiana Counties? Was David Bottorff able to join us today? Right, very well. Then Judge Spitzer, can I ask you to please give a report out on behalf of the Indiana Judges Association? Maybe Judge Spitzer had to drop off. Very well.
I was muted. I'm sorry.
Oh, it's okay. Go ahead, Judge.
Yeah, so we haven't met since our last meeting. However, what we've been dealing with primarily is the Chief Justice sent out a letter to us all suggesting what I think probably most of us were doing already, but with some more specifics that we needed to be remote wherever possible in terms of court operations. In addition, most or all counties have suspended the jury trials. And I think those have typically been suspended till at least January of next year. And so that's going to have some impact, obviously, on jails and on the system. And so our members are just sort of addressing those concerns, and we think we're going to be there for the foreseeable future until we work our way through the vaccine process. So with that, happy holidays, everybody. That's all I have.
Thank you, Judge. I'd next call for a report out from Ralph Watson on behalf of the Association of Community Corrections Act Counties. Ralph?
Thank you, Justice Goff. Our association really doesn't have much to report at this time. We'd like to thank Chris and her staff for turning the contracts around, and that's really helpful. And I know a lot of people have talked about how quickly that has occurred. So, and I'd like to wish everyone happy holidays.
Thank you, Ralph. And then I next call on Kirsten Haney on behalf of the State Budget Agency. Kirsten, anything further to report?
Nothing else really to add. I would just add in for those agencies that don't have a budget hearing next week, we will be reaching out to them after that week and prior to probably January 4th to let them know what that finalized budget is going to look like. So we'll definitely be busy on our end the last few weeks of the holidays when it tends to get a little bit quiet around here. So we'll be in touch on that part. But other than that, nothing else to report. Hope everyone has a really nice and safe holiday.
Thank you, Kirsten. And next call on Mark Rutherford on behalf of the Indiana Public Defender Commission. Mark?
Thank you, Justice Goff. As usual, our priority in this legislative session is making sure that we're fully funded. This is maybe a difficult year, but we need to be fully funded so that the counties get what they expected in the way of reimbursements. So that's always our priority for the commission and what we're focusing on. But as this group agreed on and talked about was misdemeanor reimbursement as well. You'll see up on your screen right now, preliminary draft that's prepared. Senator Ford intends to file this in the Senate. We've started in the House before, but we're starting, it looks like in the Senate is where it's going to start this year. And then if it is passed by the committees in the Senate, then goes to the House. We're very grateful for Senator Ford, again, once looking to help with this and to do this. So that's our second priority from a legislative standpoint. Also, you'll be receiving by email after this another document that basically is, and you'll see it right now, This is just a little sheet that we've put together, talking about misdemeanors, why reimbursement is a good idea. Might be helpful for you if this is something that you're approached upon, to be able to talk about why it can be beneficial. And in my opinion, short term, maybe a little bit more money, but long term, huge benefits and should save money. And in fact, in my opinion, will save money. And also means that we have a better court system and better results overall. We have our next Public Defender Commission meeting on Wednesday, 2 o'clock. More of the people, the merrier is what I look upon, what I like. I find personally that the more we have participating, it helps us make better decisions. And one of the things that I like to do, and the commission members seem to like to do, that unless we have a reason not to, we often will take questions or comments from the crowd, and we learn a lot from that. So we do like people there to talk and help us make the best decisions possible for the commission's mandate. Thank you, Justice.
Thank you, Mark. I'm not sure whether or not Senator Talion had to drop off. I'd ask for a report out from Senator Talion if she's on behalf of the Senate Corrections and Criminal Law Committee. And I don't think we have any members of the committee still on the call. Are there any members of the House Court and Criminal Code Committee on the call? Very well, hearing none. Doug, I know that you're, I think, still on the call. Do you have anything to report out on behalf of the governor's office?
Thank you, Justice Goff. I don't have anything further for this meeting.
Thank you. Is there any other business council members have to bring before JRAC? Hearing none. As indicated earlier, JRAC's next meeting is scheduled for Friday, January 29th from 1 p.m. to 3 p.m. Eastern Time. An invitation for this meeting has been forwarded to members. Thank you all for taking time to participate in today's meeting and for your continued work serving our Indiana communities. Thank you, everyone. Have a great weekend.
Thanks, Judge.
Thank you.
Thank you, Justice. You too.
Thank
Bye,
you.
everybody.
Thank you. Bye.